Welcome, everyone, to the Insolvency Law Academy's Insolvency Scholars Forum podcast series. This series is on cryptocurrency and AI issues in insolvency. My name is Laura Coordes. I am the co-chair of the Insolvency Scholars Forum and a professor of law at Arizona State University, Sandra Day O'Connor College of Law in the United States. And today I am very excited to be joined by Dr. Charles Mack. Charles is a lecturer in law at the University of Bristol. He holds numerous fellowship and academic affiliations at places such as Stanford and the University of Hong Kong. He has expansive research interests. His expertise includes insolvency law, sovereign debt restructuring, trust law, financial regulation, technology law, and dispute resolution. So we will definitely be touching on a few of those today. Welcome, Charles. I'm so happy to have you here.
Thank you so much, Laura. It's a real pleasure to join you and to be part of the Insolvency Scholars Forum. I've followed the Academy's work for some time, so it's good to be here.
We're very happy to have you. To get things started, I wondered if you could tell us a little bit about what has motivated your research in these areas, AI, competition law, blockchain. Was there anything in particular that really sort of inspired you to start researching in these areas?
Well, my home is really insolvency law and sovereign debt restructuring, and that is where the interest begins. So there was no single dramatic case. It was a trend that grew out of the questions I kept meeting in that work. So restructuring depends on trust between many parties who often do not trust each other. For example, like the creditors, debtors, and advisors all need a shared and reliable picture of what is owed, what has been paid, and who ranks where. So a great deal of time and cost goes into building that picture and into arguing over it. So sovereign debt makes the problem larger still because there is no single court or bankruptcy regime that binds everyone. So once I framed the problem that way, technology became hard to ignore. I began to wonder whether blockchain and smart contract could give every side of a shared, trustworthy record and could take on some of the routine tasks or steps. Basically, whether they could make insolvency and cross-border debt resolution clearer, quicker, and fairer. The questions became a real strength of my research. So from there, competition law followed. The same technologies that can help restructuring can also concentrate power in wider markets. And I want to understand how the European Union and the United States each responds to that. So that's why this is where my work with the Transatlantic Technology Law Forum at Stanford sits. So the path ran from insolvency and sovereign debt into technology and then moonlighting competition.
I love that. I love that trajectory. That's just fascinating how one thing leads to another, just quite naturally. So turning a little bit to competition law and I wonder if you could tell us a little bit about that and how, in particular, AI use has shaped or affected competition law.
So there are two main ways that artificial intelligence, AI, has changed the field. The first is pricing. More and more firms set their prices using algorithms. On their own, that is perfectly lawful, and it is often good for consumers as well. The difficulty comes when competitors rely on the same pricing tool fed by the same pool of data. Prices can then move together without anyone even ever signing an agreement. That strikes at the heart of competition law because our rules were built around the idea of an agreement or a concerted practice between people, not machine AI. A good example is the real page litigation in the United States. Landlords use common revenue management software to set rent. The Department of Justice and a number of states argue that these amount to a form of coordination. Late in 2025, the department reached a settlement that restricts how RealPage may use live competitors' data. California went further still. From January 2026, it amended its Copyright Act to ban the use of a share pricing algorithm as part of the agreements to restrain trade. So the second way is data. AI runs on data. Without data, there is no AI. The entire system is based on data. So the firm with most data trains the best model, attract more user, attract the most user as well, and then gather still more data. That loop can entrench the firms that has already dominant, and it can raise the barriers for anyone trying to enter the market. So this is what my transnational work calls the data accumulations. So AI has not replaced competition law. It has put the old concept under the real strain.
That is really fascinating. And so, as we deal with these new innovations and new challenges with respect to AI and competition law, are there particular regulatory or enforcement challenges that you see, whether with respect to AI in general, algorithmic decision making? Sort of what are the big challenges that are out there?
So there are several challenges stand out, and they are connected. So the first is proof. Competition law usually looks at the meeting of minds, emails, meetings, or shared plans. Algorithms then reach a coordinated outcome with none of that. Regulators are then left asking whether prices that move together, produced by machines, are unlawful at all. And if they are, who should answer for it? And that leads to another challenge, the second challenge, which is attribution. If an algorithm learns to coordinate on its own, is the firm responsible or the software provider or neither of them? The real page cases suggest that enforcers will hold firms and providers to account where they share non-public competitor data. Even so, the boundaries are still being drawn. In August 2025, an appeals court dismissed a similar claims against the hotel in Las Vegas because the connection there was weaker, so the courts are moving carefully. And third challenge is opacity. Many models are a black box, even to people who use them. So that makes both compliance and enforcement harder. The fourth is pace. Technologies move faster than legislation and litigation. We all know that. So by the time a case concludes, the two has already changed. So the fifth one is borders. Algorithms operate globally, while regulators are national or regional. Different rules in different places leave gaps. So my own view is that we do not need to throw out existing law. We need to give regulators the technical skills to understand these tools and to be clear about the duties a firm takes on when it chooses to deploy them.
That makes a lot of sense. And that I think will be a good and valuable perspective as we sort of start to or continue to think about these challenges. Shifting gears just a bit to blockchain, what kind of is the landscape for blockchain technology, and are there particular challenges that you see regarding regulation or even just guidance for looking at and thinking about blockchain?
So let me start with opportunities because they are real. A blockchain is simplest a shared record that is very hard to tamper with. For insolvency and that's restructuring, that could help a great deal. Think of a tracing asset, verifying claims, and keeping a register of creditors that all sides can trust. Smart contracts, which are simply a pieces of code that runs on its own once conditions are met, just like a vending machine, could automate routine steps such as releasing a payment. In work with colleagues, I have argued that these tools could bring more transparency, efficiency, and fairness to insolvency processes. Similar ideas applied in mediations and dispute resolution. So the central challenge sits on the other side of the same coin. Regulations assume there is someone to regulate. A truly decentralized network may have no operator to license and no one hold responsible. The European Union crypto regulations, the MICA, shows this plainly. It brings issuers and service providers within the clear framework, but fully decentralized finance falls outside the scope, precisely because there is no identifiable entity running the system. So there are further difficulties. A blockchain does not sit in its own country, so jurisdiction becomes complicated. There is a gap between the idea that code is law and what the law will actually enforce, especially when the code does something the parties never intended. And there are familiar concerns about fraud, consumer protections, and vulnerability. So the task for regulators is to capture the genuine risk without shutting down the useful applications. Often that means that regulating the people and businesses around the technology rather than the technology itself.
Thank you for that. That's really helpful to just conceptualize that a little bit. And so coming back to that question of regulating, is there a particular, it could be a jurisdiction or just even simply an approach that you think is doing something particularly well when it comes to, I guess, either AI or blockchain? Are there things that, are there sort of examples that we could hold up and maybe learn from?
So I would rather not crown a single winner because different jurisdictions do different things well. For example, the European Union has chosen the broad uncertainty, as MCIA gives crypto a single rulebook across the block, and main obligations of its AI Act began to apply it recently. So the strength is legal certainty and a level playing field. The risk is that broad and detailed rules can be slow and they can struggle to keep up. So this is partly why the union has already proposed adjustments to the timing of the AI Act. Hong Kong, another jurisdiction in Asia, offer a more targeted approach. A stablecoin ordinance came into force in August 2025, and it regulates issues of fiat referenced stablecoins through a licensing regime under the Monetary Authority, the HMA. It does not try to regulate everything at once. I have written on this, and I think it shows values of moving early on a specific, well-defined risk. Singapore and United Kingdom have leaned on regulatory sandboxes, which lets firms test new products under supervision before the full rules apply. That approach gathered evidence and it helps the regulators build understanding before the law fixed. The United States showed yet another route. There is less comprehensive legislation and more enforcement through the existing law and courts, and the pricing cases showed alongside actions at state level. The lesson is that no single model is complete. Broad frameworks give certainty, but they can lack. Target rules and sandboxes are nimble, but they leave the gaps. So I would draw three lessons. Match the rule to the specific risk, build real technology capacity inside regulators, and above all, coordinate across borders between the technology certainty does not respect them. So the aim throughout should be regulation that protect people without closing off innovation that genuinely helps.
I think that is a very smart way to go. And I really appreciate you laying all of this out and giving us the lay of the land on all of these issues that are so important for us to be thinking about. So I just want to thank you so much for your time and your expertise, Charles. I want to thank everyone that has tuned in to this podcast from the Insolvency Law Academy. Thank you so much and have a lovely day.
Thank you so much, Laura. I've enjoyed this a great deal, and thank you everyone for listening. Thank you.
Thank you.